Bryan Kohberger is looking for a change of venue in his trial. In this episode, just what factors go into a court determining whether or not they grant a change of venue.
The defense wants to change venues. State said, no way. And the defense is still trying to fight with their point. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have a wonderful panel. We have our classic Yoli Medina joining us. Yoli, how are you today?
I'm fine, thank you. Thanks for having me.
Thank you. And then also we have Intern Red. Hello, Intern Red.
Hey.
And then for a special treat, we actually have criminal defense attorney Kevin Curtis. Thank you for joining us today.
Thank you for having me.
Yeah, so as in our previous episode, we talked a little bit about the defense re-arguing their point, saying we need to change this venue. There's more resources elsewhere. And today we are going to dive in a little bit more about the details on that. Andrew, I will pass this off to you.
Well, Attorney Curtis, thanks a lot for being with us today. You're out there. You know the legal culture in Washington State and also in Idaho. So I was just curious, now that we've had the defense motion for change of venue, the prosecution's objection, and now a reply, what do you make of all of this, and what did you think of the more recent reply that was filed?
Well, first, again, thank you for having me. And I think we all obviously predicted there would be the change of venue issues that arose in this case. You know, the defense indicated in January they would be moving for it based on, you know, the grounds that have now been set forth in detail in their memorandum. The state has objected. They obviously want to attempt to impanel a jury in Latah County, which is, Moscow is the county seat. That's where the University of Idaho is. That's where the killings occurred. And then the response by the defense, I think, not simply, but it mirrored the concerns they had expressed, but in much stronger terms in their response or reply to the state's objections.
Now, what's the bigger issue? One of the issues is that in the very beginning of the motion or the reply brief, the attorneys for Bryan Kohberger said there's a mob mentality. If he is convicted, if he's not convicted, the jurors are going to face this horrible backlash. What do you make of that?
Well, there's a couple things, and I'll try to explain it first in kind of non-lawyer language, if at all possible. And then if we want to go into the weeds, which to some extent is important to understand the dynamics as to what's occurring in these briefs. So from a non-legal standpoint, there's really going to be two issues that the judge is looking at. Number one, can Bryan Kohberger get a fair trial as guaranteed by both the state and federal constitution with a jury impaneled in Latah County, a small county where the crimes occurred? Number one. Number two, in the interest of justice, does it make more sense to transfer the case to a different county in Idaho? Or three, under the Idaho court rule, to bring in jurors from another county into Latah County? So those really are the two issues: the interest of justice, the guarantee of a fair trial. So that's what the court is dealing with. So now we get into the language of the briefing. And so when you start looking at the case law as to what type of prejudice or pretrial publicity or inflammatory or false information has been conveyed to the public, the court has certain standards that you're required to meet. If the court determines that the publicity, the pretrial publicity, meets the legal standard for a, quote, extreme case, that really mandates that the venue be changed to another county. So you
well, have they? Okay, I'm going to interrupt you right there and say, first of all, the prosecutor said what you just said. It has to be an extreme case. So my first question to you is, can you cite one other case in your career that is more extreme than this? That's question number one. And question number two, is that the only question? Do you think that coverage here meets that standard?
Well, first of all, yes, there are other cases that do meet this criteria. I don't want to spend a lot of time with it. But, the Shepard case, which the plaintiffs, the defense extensively cite from, was a case that, particularly when you look at the time frame from the arrest to the trial, the pretrial publicity, the interviews that were being broadcast, etc., that's an extreme case.
From 50 years ago. From 50 years ago.
Right.
Okay.
And
Cite me another case in the last 5 or 10 years that's as extreme as this case.
Well, the O.J. Simpson case was not as it was not 5-10 years ago, but it wasn't that far off. And now we move into the area of social media, which is an important factor in these briefings as well. So we talk about the traditional media publicity, and the standards are kind of this. It's not the amount of it. It is whether it really is inflammatory, whether it is inaccurate, whether it deals with inadmissible evidence such that a juror has formed a predisposition that can't be swayed by what happens in the actual trial. So now we have the advent of social media, which versus traditional media throws a whole different slant into this. We look at Idaho's leading cases on it and the factors they take into account. It's a 5-factor test, again, legal standpoint. But 2 of the factors alone are based simply on what happens during jury selection, which we haven't had. What have the jurors said under oath? Not what have they said in response to one party's survey or another survey. So the defense is telling the court, yes, this is an extreme case. Look at the amount of publicity, local, state, national, international, and look at the amount of speculation and people's opinions and all of this. So that's why you see in their reply brief the even stronger language of mob mentality and these quotes that they've taken from the survey to try to establish the record that this is easily an extreme case which merits removal.
Guys, can I be real? I think we're all thinking right now, the reason that they're dying on this hill is because this is all the prosecution has. If they don't have emotions to play off of, there's just no way that they're winning this case. Their argument is like a joke. I don't mind saying it.
Yeah. I can understand the appeal sorry, I'll let you speak, Kevin.
Well, I was going to say, with all due respect, the state's response is not going to win any Pulitzer Prizes for legal writing.
Hey, we didn't think so.
It is surprising to me that there were no affidavits, so to speak. There's no expert to discuss the survey, in particular by Dr. Edelman, along with the 3 supporting experts. But I think Dr. Edelman's work is really the primary one that would cause concern or merit substantial attention that you would want to devote to it. So I think you really are left with 2 conclusions on that. Number one, the prosecutor is banking on the fact that the judge is going to want to try to keep it in the county where it occurred. And number 2, his decision is governed by a, quote, abuse of discretion standard, which is very, very hard to overcome. Or he says, listen, I know I'm going to lose this anyway, so I'm not going to spend an inordinate amount of time and or state resources in the brief. You can argue it, I guess, either way as to the quality of the response by the state.
All right, I want to go back to something that you said before, and that is one of the points that we've made here is that, as you pointed out, Bryan Kohberger's attorneys have 5 experts, and we have them on the screen there. Edelman, who you just discussed, Murphy from TrueScope Media, Scott Sunby, a capital punishment case expert, Mr. Amani El Aliani, I apologize if I mispronounced that, and Veronica Day here. the prosecution, as you just pointed out, had no experts. So is it relevant that the score is now 5-0 if you're counting just that? Or did the prosecutor effectively, when you don't have the burden, you often just throw a lot of mud up on the wall to see if it sticks, or put another way, as Yoli has said, argue, as I've said, take pot shots. So do you think that it's relevant that the score is 5-0, or did the prosecutor do a good job in taking pot shots?
I don't think the 5-0 score is overwhelming. I think that it is significant, however, that that there has been expert opinion on one side and nothing to rebut it. So I think a couple of the other experts, I don't want to say should be discounted. They're all very well qualified. But when it comes down to the court's determination as to whether a jury or a potential large jury panel in that county has been so saturated with false and inflammatory information, it's hard for a court, recognizing the science that's in Dr. Edelman's surveys, to sit there and say, I don't have a representative Latah County pool in front of me that's been pulled from where you get, jury pools, voter registration, driver's licenses, property ownership. So I have a survey somebody conducted on the telephone. I'm not exactly sure how representative that is of the county. And that's why a couple of the major factors courts have traditionally looked upon is what has the jury panel been saying during what year. And so that I guess, go ahead.
Yeah, I was just going to say, the way one person may answer a survey over the phone may not be the way they will answer when they are in the jury box and having to answer under oath. So that's one thing that I thought about, and I was wondering if Judge might say that he's denying the motion to change venue without prejudice, so that they could bring it if after a jury is pooled at the actual trial, and there is this, outrage or bias, and that can't be overcome.
Yes, I think that, this points out the difficulties of holding a venue motion 9 months before a scheduled trial when you haven't ruled on admissibility of certain evidence, number one. And that's one of the factors as to the pretrial publicity. Has it been inflammatory? Has it saturated the jury with incorrect facts? So you don't have, any sworn testimony from jurors yet. You don't know if your jurors are going to be sequestered as to later things. So, it's very difficult for the court. They certainly don't want to start a jury pool and then, 2 days later have to figure out, do we have to move this to another county? Logistically, you want to do it in advance. But so that's the question is, and I obviously, the survey was very long. I didn't look at all the documentation. I don't know if you could say, listen, the survey respondents represented basically the same constitution as to what you would get if the county clerk sent out, 300 juror notices and had 300 jury panel show up. Is that the same representative group that you would get, first of all? And then the second question you've asked, would they say the same thing under oath? I'm not as concerned about that if I'm the attorney or the judge as to what they would say under oath yet. I just would wonder, is the survey truly representative of the beliefs, or did the way the survey was phrased, or the fact that they chose to even participate in a survey on a high profile case, does that, indicate some sort of bias in the results? But that being said, there isn't any question that this case has as much pretrial publicity as you're going to find in any case in the country. Does that make it an extreme case on its own?
Yeah.
I don't know. If I can add one other comment, though, I think when you get to the fourth factor that the courts look at, that's really the meat of the matter. And that's why we're having these discussions about stalking and social media.
What's the fourth point? I've forgotten.
The fourth factor is, if I can get it, the nature and the content of the pretrial publicity.
Sure.
So
let me ask you this.
Yeah.
Go ahead and finish that thought. I just had another question.
No. It has. Yeah. Go ahead. I answer too long, so
No, that's fine. That's fine. We've had commenters ask us, well, geez, if he doesn't grant a change in venue, is that a question for appeal? And I said, yes, of course it's an issue for appeal. But here's my question to somebody that knows the legal culture out there. I'm licensed only in Massachusetts and New Hampshire, so I'm attorney to attorney based on the rules that are applicable out there. If the court does deny the motion for change of venue, do they have to wait until the very end in case Mr. Kohberger is convicted to then appeal it to the upper courts in Idaho? Or is it an interlocutory issue that they can appeal right away?
Well, you can always attempt interlocutory appeal, but from a practical standpoint, the court and the appellate courts are probably going to deny it because they don't want to, if in fact he goes to trial and gets acquitted, it's a moot point. Right. So it is going to be in all probability, if it is denied, it will be an issue that will be raised on appeal. Fairly recently, you had a couple interesting cases from the Idaho Supreme Court, including the Lori Vallow case, which discussed venue, and State v. Ish, which discussed venue.
Yeah, do you think that'll persuade judge in this case that, they cited those three other cases, the Daybell case, the Vallow case, and the one you just mentioned. Do you think that'll be persuasive to the judge in this case?
I think it's a factor, certainly. Now, Daybell and Vallow were in Fremont County, and that had a population of about 13,000. So, that's extremely small. So from a number of factors, both constitutionally and by the court rule, that's a strain that county would not be able to maintain. But what's interesting in there is the state moved for reconsideration, saying, well, let's transport, Boise people to Fremont County. State versus Ish, which was a retrial, the state even agreed to the defense motion for change of venue, and the trial court denied it. The Supreme Court upheld it. So what that's telling the judge is I have a wide degree of discretion, and he might not get overturned if he keeps it in Latah County.
Can I say something? I honestly think that the defense could still win this case in the county that they're in if they would just put a little bit of more of a face on this guy. I feel like all of their argument is logic, and that's great. It's lovely to have evidence. That's the most important part. But the second most important part is letting, your audience know that this guy is a human. And I feel like that's, he's not even from this town. If I was living there, I would be more likely to demonize this guy just because somebody's telling me to, That was more
right. Well, let me ask you a question again, and a second question I've asked you. But if you're the defense attorney and attempting to humanize it, would you do that through pretrial motions, or would you also put him on the stand at trial?
I would put him on the stand. He has gone. Okay, I feel like people use his past against him, and they don't need to. I mean, I feel like people already think he's a murderer, but if he genuinely just addressed the things that people were demonizing him for and explained it, I think people would be like, okay, prosecution, now where's your evidence that this guy's a bad person,
Well, his past actually shows that he overcame a lot, that he has a strength, because he had been allegedly struggling with addiction. He overcame that. He was overweight. He got in shape. He went to a PhD program. He got into a PhD program. And so by all accounts, his past actually shows that he had an amount of strength to overcome these things. And so I feel like if he has that strength, that he would have the strength to overcome this trial. However, I don't know if it would be a good idea for him to testify because I don't know him. His attorney would be the best person to decide.
Attorney Curtis,
Sure.
you have handled a lot of Eastern Washington's most high-profile cases over decades. You have served on the board of directors and were president of both the Washington Association of Criminal Defense Attorneys and the Washington Defenders Association. I want to ask you, as a criminal defense attorney, we are basically ingrained to say you don't. It's their decision, of course, but you do not put a defendant on the stand. How many times in your distinguished career, and I mean that with all due respect, how many times in your career have you actually put a defendant on the stand?
I have, over the years, I believe, put only one defendant on the stand in a homicide case. And that was actually Washington State's first, quote, mercy killing case regarding a 80-year-old gentleman who had a pact with his wife who he had taken care of for 2 years, was almost comatose. And so it was a diminished capacity case. And we did need to put Mr. Jones on the case.
What happened? What happened?
Well, he had been charged with first-degree premeditated murder, so they acquitted him of that. They acquitted him of second-degree murder.
Okay.
They acquitted him of voluntary manslaughter. They convicted him of involuntary manslaughter. The judge sentenced him to an exceptional sentence below the range, 12 months that could be done of work release. Yeah. And so he worked at our office for 12 months, serving his sentence and going to the halfway house down the block.
Oh, wow. That was a good result.
Yeah, that's like a happy ending for a horrible situation.
But you never, ever, unless there are unique circumstances, you never, ever put a defendant on the stand. Ever.
This is a unique circumstance. And plus, also, I have the perfect rebuttal, guys. Have you ever read or listened to the podcast Freakonomics?
No.
Okay,
what's your point?
How to think like a
what's
freak.
What's the point? Instead of us having to go watch something and come back,
No,
what's the point?
I was gonna get to it. Okay. Well, basically, they say that a lot of people don't take chances like that because a lot of people tell them not to, even though they know that they could get the desired result. But just in case that they don't, they won't go through with that action because they don't want the judgment from trying something different.
See, oh my goodness. I do want to say, I just think about with the Karen Reed case, having the prosecution have my co-proctor read his text messages and Turtle Boy talk. It's like I'm already so traumatized from seeing laymen trying to defend themselves and trying to represent themselves. It's just like, I come on this podcast and I'm talking about
we could do an entire podcast on the factors that go into that and the individual characteristics of your defendant, prior record, what could be admitted from prior acts, all sorts of other things.
Yeah.
But to take it back to venue and back to Red's comment, I think were I the state in this case, in my response brief, I would have been arguing, they've taken a lot of survey things and talked about the people who've had bad things to say in predetermination. But here are the news reports, or here's the social media reports of a lot of people who think the state doesn't have a case, that the state is backing off on certain things, that they must not have very good evidence if. So I would be pointing out that this social media and this publicity has cut both ways.
Yeah.
And so, Judge, until we get these people in here, if you're going to make the argument that you want to keep it in Latah County, point out that there are two sides. Now, maybe it's, a little bit slanted one way or the other, but to the extent some people believe the other way already, doesn't that mean if they will listen to the evidence and if you do your vetting during individual jury selection, that you can find at least, 18 people who are going to keep an open mind? So that's why you wanted to see an expert saying, listen, those survey results don't really mean what they purport to mean as to what's going to happen in a jury selection process.
Yeah.
And so that was really lacking in the state response. There were some things that I thought he did okay with, but there were some things I thought were were really lacking, and he had a much stronger argument than what was put forth in the briefing.
I think with the
Yes.
prosecution. Oh, go ahead, Yoli.
What I
Go
was
ahead.
going to say is he could have, and it may be that he thinks he's going to lose the prosecutor on this motion, but I was expecting them, the prosecution, to get an expert to talk about all the people who are what they call pro-burgers, or people who say the state's case is bad, there's no evidence. So I thought that that's the way the motion would be countered, and I was kind of surprised that it was all argument about the surveys, attacking the surveys, but they did have they had a better avenue to go, because there are a lot of people who think that the evidence in the prosecution, the evidence that the prosecution has, is not enough, and that's partly because of the gag order.
I would agree with that. I think he kind of took the bait on the survey that the defense took him down, and he took it rather than perhaps looking at a broader picture and pointing out that survey by and in of itself doesn't even discuss the other half of the coin. So,
Attorney Curtis, I have a question for you, I guess, just from a more layman perspective. As far as the prosecution objecting towards the change of venue, at the end of the day, regardless of whether or not they believe that there's bias in Latah County, they're just doing their duty to the state by trying to object to it. They just don't really have an option to just say, you know what, let's go change venue. It's their responsibility to keep fighting regardless of what they believe, correct?
I disagree with that. If you look at the State versus Ish case, the prosecutor in that case said, listen, I've looked at the defense arguments, and I think there's merit to it. And Judge, I urge you to change venue to give him a fair trial. So that's her ultimate responsibility, is to guarantee the constitutional rights. So if the prosecutor believes that Mr. Kohberger can't get a fair trial in Latah County, he should be doing what that prosecutor did and be telling the court, that's my belief. The court isn't bound by it, as in State versus Ish. The court said, I appreciate it, Mr. Prosecutor, Mr. Defense, but I'm not changing venue. So that's the prosecutor's duty, is to make sure there's a fair trial as much as it is the defense attorney's obligation.
Well, that's everybody's duty and obligation under the Constitution, is to make sure there's a fair trial. I mean, not just to get a conviction if you are the prosecution.
Exactly. Which is the question to me, I guess, and I served only as a prosecutor briefly during my law school days as a Rule 9 third year of law school. So I was in court as a prosecutor, and I've been around them my entire career. But when push comes to shove, you put all these factors together, it seems to me to be too risky a move to try to attempt to keep it in Latah County.
Yeah.
I think it just risks too much avenue for appeal. I recognize the Supreme Court of Idaho has given judges wide discretion, and on cases that have horrendous facts too, they've upheld the denial of a change of venue. But I think what strikes me the most, get away from the survey, is and the defense hit on it fairly well, and I think they can hit harder on an oral argument, is the interconnectivity of the community and the amount of people that are connected with the University of Idaho and with law enforcement and with medical and with first responders and grief counselors. And to me, were I the judge, that is the factor that I believe most likely would lead to predetermination. There's going to be water cooler talk among people who have knowledge of the case regarding facts that probably aren't admissible at trial, that's just going to permeate into that interconnectivity and knowing other people associated with that. You combine it, the defense obviously has given the court more than enough of a hook to hang a change of venue on. And if I were the prosecutor, obviously he has discussions with law enforcement, his witnesses, the victims' families, and
I think I read somewhere that over a half of the people that live in Moscow have some kind of a connection with the University of Idaho and our old friend Scott Green. People can say, oh, sure, I work at the university, but I can be totally objective. And you and I both know that when people say that, that doesn't mean it's true. That doesn't necessarily mean that they can be fair and objective. They have
Correct.
that institutional bias that their paycheck or comes from University of Idaho, or they're paying money to University of Idaho to educate their kids. But one, as I was hearing you talk, one thing that came to mind was, I think the direction that the prosecution is pushing this is, no, let's wait and see. We don't need to change venue now. Let's wait and see until the trial next summer, June 2nd or whenever it is, and we'll start the process of questioning the veneer. But what if they start questioning people and the serious questions come up? Are they really going to either at that point start busing people in from these other counties, or at that point, financially, economically, practical, would it be even practical to send the trial down to Boise, Idaho at that point? Isn't that kind of a risky thing to just wait and see?
It is. So, as somebody pointed on the panel earlier, I can't remember if it was Yoli or Laney, that whatever the court, if the court denies the change of venue at this point in time, it still is going to be without prejudice. It's going to be based on, I'm going to leave it open because depending on what happens during jury selection, I may reconsider. So,
okay,
the court can either make a decision right now, I'm moving it, so we all know, and we can do it logistically. He can say, you know what, I'm going to start and I'm going to direct a jury panel come out. I can't remember. Is the trial date June 3rd or?
It's in June. I don't know, 2025.
Yeah, June. Yeah, June 2nd, I believe it is. Yeah.
I'm going to send out questionnaires and we're going to bring in a panel a couple of weeks before, and simultaneously, he may be making arrangements with the Boise court system that they, be ready for, and they have courtrooms reserved in the event he makes that decision to change it.
But wouldn't that be crazy? I mean, you've got these experts in Miami and, Chicago, and that. So now the experts have plane tickets to fly from Miami to Boise, and
Right.
now they're going to have to fly, from Miami to the little airport between Pullman and Moscow. Now they've got to change or rent a car. I mean, wouldn't that be chaos? That was a rhetorical question, by the way.
Well, yeah, it would be extremely difficult. It wouldn't be economical. It would be very difficult for the parties, the witnesses, and even the defense to be doing that type of scheduling. Likewise, on the other hand, the state suggestion that, we have enough population that we can interview 1,800 jurors to get 18. I mean, you do that and you're talking about, a trial that's going to last a decade, because jury selection is going to take like 5 years.
Yeah.
When he says if we get 1,800, we can get we only need one out of 180. That doesn't make sense. Nor does transporting a jury daily. That doesn't make sense.
No.
So it's really, the judge is really, I think if he's inclined to change venue, he'll grant the motion and just say, listen, I understand that I don't have to, and I believe the good people of Latah County could be fair and impartial, but I want to circumvent any appellate issues, and I want to be able to have everybody plan. And from my standpoint, I think that would be the cleanest and best way to do it. You can argue till the cows come home. No pun on Moscow, but whether it meets the criteria, unfair, have the facts that aren't going to be admissible at trial, or the suggestions of stalking and the social media theories, has that infected them or not? You can argue that. Does it meet the abuse of discretion standpoint? Or you can just say, listen, folks, this is one of those, biggest cases, this decade. And let's take that out of the equation. Everybody knows what's going to happen, where it's going to happen, and let's get ready for trial.
Well, let me ask you this, and it's not an issue now. So we've mentioned it, but it's not an issue now. But how do you sequester a jury in a case that's going to take 3 months? And what impact does that have on the psyche of the jurors? I mean, at the end, I want to get the H out of there. I wouldn't want to deliberate more than 5 minutes.
Oh my God.
How practical would it be to sequester a jury in a case that they say is going to last 3 months?
Well, that's why, first of all, you don't. So, and that's why transport is another issue. If you transport from another county, which the prosecutor in the Vallow case suggested, saying, "Hey, let's bring Boise people over here." First, if it moves to Boise, I don't think the court is going to sequester the jury regardless. But first, remember, jury selection is probably 2, 3, 4 weeks of that. So not every juror is in courtroom during that time period. So the trial period on guilt is probably, I'm going to guess, closer to 4 weeks, 4 to 5, 4 to 6.
Yeah.
Now, under Idaho law, and I think under every state law, but I'm not sure, but under Idaho law, if he is convicted of a capital offense, then the death penalty phase, the jurors are required to be sequestered during that phase of the trial. But I would be fairly confident that this jury is not going to be sequestered throughout the entire proceedings, only during the death sentencing phase, if
That makes sense.
conviction happens.
Have you ever had a trial of that length? And I'm not talking about a simple trial that we've all done, I'm sure, that lasts a couple of days. Have you ever had a trial of this length where they actually set a firm start date, which is normal in every case, but also a firm stop date that the court has said that the trial is going to last from this date to that date? And A, have you ever had a trial go exactly as you thought it would go in terms of the length of it? And B, what do they do if it goes over?
Right. My experience has been that generally criminal cases go a little faster than the parties anticipate. It's slow to get rolling, but once it gets rolling, it moves quicker than people think. I think the longest criminal case I had was probably 8 weeks, and that was a death penalty case. And it did not go to the penalty phase. So had it gone to the penalty phase, that would have probably taken another week to put on evidence, and who knows how long the juries would have been deliberating. I've had a civil case go 6.5 to 8 weeks. Civil cases can go much longer because they can also be bifurcated. But realistically, I think I forecast when we first talked probably 8 to 12 weeks for this case, from the inception of jury selection to, if it went to deliberations on the death penalty. And I still think that's a fair estimate of time, is 8 to 12 weeks. And what's going to happen is if you start running out of time, the court's going to have to clear off whatever they had that they thought they were going to have to take care of, and they're going to have to finish this case.
And I guess the other question is, how does that court in Idaho, how do those courts in Idaho schedule their day? I know in Massachusetts, when we try a case, generally, you're supposed to be there at 9 o'clock, but by the time you really get going, it's like 10 o'clock. And often they'll go to 1 or 2, and that's it, because the court has a 2 o'clock motion session or whatever. So will they try this on full days, or will it be kind of like a part-time? Like in the Karen Reed trial, there was 1 week where they only had 1 day of testimony, which is why that case took over 2 months. So what will the schedule be like? Will they try it from 9 to 5, or will they take their jolly old time with it like they do in Massachusetts?
Each court and each judge, even here in Spokane, has a different quote trial schedule, and some run these things from 8:30 to 5:30, and some of them you don't get much trial time in during the day. I think I'm pretty safe in assuming that in this case the court will devote 5 days a week to it. They will not be hearing other matters in between that. They'll have somebody else handling those issues that are occurring in Latah County, so that the judge is free to deal only with this case. That being said, however, there still are motions and things that happen during the day of trial that you need to pick up on the morning. And so sometimes, the jurors are delayed on hearing testimony because you're arguing on motions or admissibility or other issues that have arisen during the previous day. So you don't get, 8 hours of trial testimony a day. You're generally lucky if you get 4 to 5 hours.
Yeah, exactly. So that's why that was part of my question. I mean, they've allotted 3 months. Is that enough, or is that too little? I mean, we just don't know. Get out your crystal ball now. Mm-hmm. Get out your crystal ball. What's going to happen with this motion? Is it going to be allowed, or is it going to be denied?
Wow, that is a really, really difficult question.
And it was unfair. And before this interview, I promised you that there would be no gotchas. So it was an unfair question.
That's okay.
Unfair question.
My gut instinct is we're going to see a change of venue. Whether we're going to see a change of venue at the hearing on August 29th, or whether they defer it and waits to a later date till he wants to hear from the panel, or whether he grants it right off the bench on the 29th. I believe between now and the time of trial that the trial is not going to occur in Latah County.
All right. Yoli, did you have another question?
Yeah, I did. One of the questions I have, it's about the way they phrase their motion. Oh, it's an objection to the state's motion to change venue rather than an opposition to change to the motion to change venue. And is that just a distinction without a difference, or is there really something to it? Because when there's an objection, it seems like, well, when there's an opposition, you oppose it on the grounds where you would get an expert, you would do what we were discussing and point out all the Kohbergers or all the people who are, and in this objection, they just argue and attack the experts that the defense has. So I'm just wondering, objection, opposition, is there something to that?
I don't think in this case there is a reason for that, other than, again, I don't think precise language or the quality of the brief was spectacular from the state. I guess I would look at the conclusion. I don't have it right up in front of me. I would look at the conclusion of the state's brief and see at the end whether they request the court to deny the motion, which, you're right, would really be in opposition to the motion. Versus an objection to the motion, but I don't know how they phrased it in the conclusion. But I don't think that there's anything intentional in that. Okay. Again, distinctions. This whole issue of the stalking and the cell tower in the vicinity and near, is that a backtrack? What is that? What is going on in the legal briefings on that issue? And that again ties back to the defense arguing to the court, listen, this is inaccurate information that has permeated the community, and the prosecutor even had to backtrack from it, and this just demonstrates why we have to move it. That's what makes this, a case, that an extreme case, and the prosecutor trying to come back and say, hey, no, we never really said that, it's accurate in a sense. So that it's back to that fourth factor we talked about. That's why you're seeing that back and forth as to the social media and the stalking issue is inflammatory and inaccurate. Yes or no? What does that mean? And that's why they're pounding on it in their briefings.
Yoli, did you have another question before we move on?
I think he answered it. It was the one about whether the judge might wait for voir dire to change venue, and he answered that.
Okay, yeah, and the procedural question that you had before about whether there's a difference between an objection and an opposition. I know that I've been supposed to have been following court rules when there was a motion, and I was supposed to file an opposition, and I accidentally typed in objection. So I didn't know if it was like a typo, like I'd done, or whether it was substantive. So
because in California, it does make a difference if
right,
you're filing an objection or opposition. That's
Well, it wouldn't be the first time I made a little mistake on something like that. But Lainey, Red, do you guys have any more questions?
Oh my goodness. I mean, it's not as much of a question as it's just a statement, probably reflective of my pessimistic nature, but I would be surprised if the venue changes. I don't know. It's just something about this case that doesn't, I think the logical thing is to change the case, you can keep judge or whatever, but I don't think he's going to grant it. I don't see it. I feel like, I don't know.
I agree.
I feel like there's just so many things that don't necessarily, they seem like they would be easy. You would think that it's just like, let's change venue. It's just like, okay, you know what? Why not? It's a lot of extra driving, but just get it out of the way. I would love to see that, but oh my goodness, I feel like after seeing the Karen Reed, I keep going back to the Karen Reed case, but it just seemed like that was such a mess where I'm like, oh my God, this is going to be number 2. I agree that a quadruple homicide is a very exceptional condition and deserves to be changed. I don't know if we're going to see that one.
All right. I want to close out with an issue that we actually started out with, and that is, let's take a look at the briefing, the document that we're talking about. And There it is. Okay. So I'm gonna. This is a long-winded question, but it's a question, Attorney Curtis. And we're taking a look at the very first page of the reply to the state's objection to the defendant's motion for change of venue. The pressure to convict Bryan Kohberger is so severe that Latah County survey respondents said if he wasn't convicted, quote, they'd burn the courthouse down. Outrage would be a mild description. Quote, they would probably find him and kill him. Quote, there would likely be a riot and he wouldn't last long outside because someone would do the good old boy justice. Quote, enraged, strong opinions, firing of officers. Quote, riots, parents would take care of him. The mob mentality within the community is the exact reason that statutory grounds prior to selecting the jury exist to move venue. Attorney Curtis, have you ever seen something so strongly worded as that? And B, if granted all that's true, it's right in the motion there, how can the venue not be changed in good faith?
Well, the answer to that is no. I haven't quite seen that before in my change of venue cases, which have been hotly contested, and those weren't as much the concerns as other type of concerns. And I guess I don't doubt that some people in the community responded that way, but to some extent, I guess that's the problem with the survey. That is, even if some people feel that way, that's water cooler talk. Those people are not going to be on the jury. Obviously, they're going to get excluded. We've had people during death penalty qualification saying, hey, listen, do you believe in the death penalty? And they respond, yeah, I'd like to be the one that, shoots the bullet or drops the thing. So to the extent that you have 10 or 12 people in Idaho in the survey that responded with that type of language, I understand the defense's need to get those type of comments in to try to point out this is a, quote, extreme case. But no, I haven't seen that type of language, but I don't think it has a tremendous amount of effect on the court's decision.
I don't either. Okay, closing thoughts. Anyone?
No, I think
I have
you've
nothing
answered
in
all our
particular to
questions.
say. I mean, ultimately, I kind of think I'm the mindset where it's like, if I was a member of this community and felt a certain way, felt really strongly, like, for example, that he's guilty, I feel like at this point, if they're up for jury selection, I feel there's people, I want to believe in the good of people, and maybe I'm a bit pessimist this episode, but I almost wonder if there's people that would just pretend to be more neutral than they are. Obviously, it's a whole process designed to find and pick and ask very specific questions to find those outliers. But oh my
And
gosh.
that goes back to my freakonomics thing. People will literally pretend like they don't know things to fit in.
Yeah.
Or they will just avoid the actual,
Sure.
action to get the desired result.
There's
It's
no
like
question that
answering the
people
correct
do that.
answer.
But if the case is circumstantial, as and depending on what comes in or not, also remember, which I think the state could have pointed out, Idaho and northern Idaho, is not a bastion of governmental support at times. I mean, there are a fair amount of people who don't trust the government and question the government. And if it's a circumstantial case, they may sit there and say, hey, you guys, you don't have anything. I mean, I am not going to follow along and just, convict because you basically think you've got this guy, you've got to prove it. So I to the extent there is another side, maybe not as strong as the pretrial publicity pointing at him, but you would think that if it is a weak case, Latah County isn't that bad of a place to try to find you only need one juror to hang, on a conviction. So, you could argue that from a North Idaho standpoint.
Yeah. All right. Attorney Curtis, thank you so much for your time. You've been really generous to give us this time. I found that your answers have been really instructive, and we've all prepared our questions in advance, and you've answered them all. I find this really helpful, so I thank you a lot for your time. One of the issues we go, and I know it's a pet issue of mine, but my undergrad degree is in media, and I really took offense that both the prosecution and the defense kind of drew a line that the old school standard media had safeguards, and those horrible YouTubers and terrible TikTokers, they're inflammatory and awful. And I found there's good and bad on both. I mean, there are a lot of attorneys out there that will actually show the hearings and show the pleadings and go through them and take questions from their commenters over on the side and explain, here are the elements of the crime. Here's what evidence is. Oh, here's the evidence rule. Oh, here. So, and on the other hand, those old traditional standard broadcast people, they compress it all into, if you're lucky, a minute and a half. And they've actually, some of the big boys have and girls have put on specials, the case against Bryan Kohberger. And there was a new one this week that shows the fuzzy video of the car driving around, and asked the producer of that particular show, are you sure it's this car? Oh, I'm absolutely sure. Why? Oh, I have a feeling. And this was placed on one of these, standard old dinosaur TV networks as though it was true. So I don't know. It's just it's an observation that I make frequently that, if they can't get it straight, that people are now watching YouTube, and that's forming people's opinions. And oftentimes the creators are better than the idiots. I mean, the people that are producing the big media stuff. I don't know. Have you noticed any of that, or have you tried to stay away from the crazy stuff?
Well, I have a couple thoughts on that, and the first one is, and yeah, was it WKRM or where did you cut your teeth on TV?
Me?
Yes.
Oh, I worked at I worked at a couple of different places. I worked in public television in New Hampshire. I worked at the ABC affiliate in New Hampshire, and I also was a news writer at a couple of different places, including a national network.
Right. So first of all, I'm sure you share. I mean, the Fourth Estate, I mean, the press is just so invaluable to our democracy, and this exchange of information, the traditional media doesn't have the time to go into depth with it, that certainly now more channels other than the standard networks and social media have more time to delve into it, more time to talk about it.
Right.
So at least in terms of publication to the masses, what is being said about Bryan Kohberger is no different than what would be said about O.J. Simpson or Sam Shepard, or go back to, an 1800s murder case that people would be talking about within their communities. It's just that our community and technology has allowed that to be an international audience. People are going to have their theories. They're going to have their conspiracy theories. They're going to hear something and believe it's true and argue it. Yeah, that's human nature. That isn't changing. The media in which it is, and the audience it's reaching, and the speed in which it's reading has changed. But really, overall, those things are no different. And yes, I mean, you have to be intelligent enough, I guess, to start watching a program, whether it be, on TV or on network or on social media, and say, hey, listen, I don't think that thing is being fact checked. That doesn't make sense. And you've got to, make some independent judgments about, how much you're believing of what you're being fed.
Yeah. So I guess that was a roundabout way for me in thanking you for giving your time to us, in that you've kept us above the board, I would like to think, in contrast to some of the stuff you've seen in the big media, because you've come to us, you've given us your insight based on your knowledge and expertise and experience. So I want to thank you for that. So
thank you.
Thank you. Have a good one.
Okay.
Bye. Congratulations on your internship, Brad.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.